If Professor Tladi's nomination is accepted in November, he'll be a judge on the bench of the International Court of Justice. Professor Tladi was nominated by Cabinet to be South Africa's candidate for that position. Professor Tladi is a professor of international law at the University of Pretoria. Just last night, he delivered a lecture about solidarity in international law. It comes at a time that South Africa has been critical of the International Criminal Court, alongside many other countries on the continent. Professor Tladi, good evening to you. Thank you so much for your time. So we don't have any news yet on who exactly is going to fill this position, but what have you found has been filling your time? Are you waiting in anticipation or just getting by with the order of business?
I wish I were waiting with anticipation. Unfortunately, for this position, one has to campaign. So I've been doing a lot of traveling. In fact, I'm at the airport at the moment. I've been meeting a lot of representatives of different governments who will be voting in November. Trying to convince them that I'm the best candidate for the job. So that's what I've been doing for the last 2-3 months.
And it certainly helps to contextualize then the address that you gave last night, because it's really around the terrain that you may potentially be entering into, and a view that I think is important for us to unpack. International solidarity when it comes to international law, especially as it relates to countries which we know are sovereign entities. Why that as a theme?
Yeah, I think that's an important question, and I'm glad that you framed the question in the way you framed it, as a question of solidarity on the one hand as an approach to international law, and on the other hand, sovereignty. So traditionally, international law has always been understood to be based on sovereignty. There was a landmark ruling in 1927 by the Permanent Court of International Justice that said, unless there is a specific explicit rule prohibiting states from doing something, then they may do it. That's perhaps, an extreme version of sovereignty. But over the years, it's always been understood that unless a state has consented to a particular rule, then that state isn't bound. And so, of course, by definition, states are only going to consent to those rules that are either in their favor or that don't harm them. The approach, the emerging approach, at least as many commentators would say, the emerging approach is to base international law more on communitarian ideals and solidarity, and so that would suggest that there are greater goals beyond sovereignty, and that sometimes international law would reflect these goals and objectives and values even if states haven't consented, even if it undermines sovereignty. So for a long time, for a couple of decades now, there has been this debate about exactly what is it that sort of underlies modern international law, with some commentators saying the two visions of international law are existing side by side. And that's really what the lecture was about, sort of trying to identify exactly which is the dominant approach to international law. I think obviously most right-minded people would say, an international law that's based on solidarity is the way to go. So really my lecture was to ask whether or not we have arrived at this place, we have arrived at nirvana, where international law is based on solidarity.
How much would you say that the contemporary politics of the day, and this is really sort of the debates that you and I will be mindful of, whether it's, the realignment of global politics, who exactly gets to claim the hegemon position, but to what extent would you say that some of these debates have an impact and actually influence international law, and even how it is interpreted by countries?
Well, I think it has a huge impact, if not the most dominant impact. And part of the point that I was making is that what a solidarity-based international law would do would, in a sense, sort of reduce the impact of power and geopolitics on the making of international law. But it's clear that it hasn't, right? It's clear that much of international law ultimately depends on bargain. And bargain, as you know, always depends on bargaining power. Mm-hmm. And in our system, bargaining power is, military power, economic power, and influence. So of course, all of those things remain extremely dominant. The last part of your question raises an interesting issue of interpretation. And I'm glad again that you make the point that it's the states themselves that interpret international law by and large. I mean, you do have courts, but by and large, it's states ultimately that interpret international law. And that interpretation, which interpretation wins out, also is very often influenced by power. So, I mean, absolutely, global politics, geopolitics play a huge role on the nature, structure, and content of international law, whether we like it or not.
It, of course, I think comes down to why a position of this nature is important, and even why a nomination like yours is important, because when we look at the continent as a whole, there, of course, remain very serious grievances around that very issue, that because we don't necessarily have the economic military power that the West often brings, we feel we're on the back foot when it comes to some of these conversations. There's a greater accountability expressed or expected of countries on the continent, but that, of course, is not always reciprocated.
Yeah, I mean, look, that's true. I think it's hard to argue against that. Although what I would also say is that it's also important that you don't stop looking in the mirror. We also have to look in the mirror, and I mean, it is true that there are many things that are beyond the control of African states. There are many things that are beyond the control of the South, but there are also many things that are within the control. And sometimes I don't know what the word is, we shoot ourselves in the foot, in a sense, in the sense of things like preparedness, going into negotiations for a treaty and ensuring that you're prepared. We have, as a continent, as the South, we have the power of numbers. And yet, I mean, I've written many papers in which I say, here's where the South started, and look at the outcome of the agreement, and it doesn't reflect the aspirations of the South. Why? Because the majority of the negotiating partners were from the South. So how is it that the instrument then that's ultimately negotiated? So the point I'm making is a lot of it also has to do with preparedness. A lot of it, I think, also requires that we look in the mirror. That's not to take away from the point that you make, because I think it is true that sometimes influence plays a role. I mean, I know of circumstances where in the course of a negotiation, a state would think, well, I get my aid from that state, so I shouldn't be too vociferous in responding against them. But I think there is a point to be made about sort of the strength in number, which I don't think has been used a lot, except perhaps in General Assembly resolutions where rules are not created. But in rule creation, I don't think that states of the South have adequately, used the strength in numbers, so to speak.
I think one of the other aspects that becomes important, especially when we're talking about international law and the role of states, is to sort of go back to intent and understand why we needed an international law framework in the first place. And at least as far as I'm concerned, it really has been about trying to create what is a more humane world, a more humane society, where even the most vulnerable, regardless of the boundaries within which they find themselves, are able to still enjoy the benefits, of being human. Do you think that that is still at the heart of what governs decision-making, what governs motives in an international law framework?
Well, Kathy, I think what you've described you've just basically described an international law based on solidarity. I mean, I think I would phrase the question differently. The question would be, have we ever had such a system? I don't think we've ever had such a system. I think that what you do see in the sense, in the movement of international law post the Second World War, you do see greater attempts to have particular rules and particular regimes that reflect that, but you don't have that as sort of the legal system. And so, in the area post 1945, we have seen a growth in international human rights law, which, I mean, at its core, it's about the human condition. And so all of those things that you've talked about, we have seen a change, a shift in the governance relating to the environment, right? So where the environment is a lot more about cooperation for global governance rather than sort of seeing what we can take out of the the natural resources, right? And so you've seen emergence of rules such as the ones that you talk about. We've seen, for example, the emergence of international criminal law, which didn't exist as it exists now before 1945. All of those things are inspired, motivated by the very same considerations that you're referring to. But I guess the point is that if you're talking about an international law based on solidarity, then it shouldn't be that you have pockets of that. It should be that at the heart of every decision making, at the heart of every rule making, are those concerns that you've identified. And I'm not sure that's the case. Even in fact, when it is the case, what you see is when of those interests, those values, those concerns come up against power, and they come up against narrow national interests. Very often, narrow national interests win out, and that's why I'm not sure that you have that system. But I think you do have ad hoc rules here and there that sort of approximate or reflect those kind of concerns.
Prof, as you go about your business, like you're saying, lobbying different countries that ultimately will have to vote, what is it that you're telling them about the difference that you in particular will be able to bring in that position?
Yeah, so I'm competing against three other Africans, and I guess the message that I'm leaving with states is, look, this is the International Court of Justice, and it's important that when you vote for the best candidate. And I give them three criteria for what I think makes the best candidate, and I describe why I fit those criteria. It's expertise, I think. It's expertise in international law, it's practical experience in international law, and then I think ultimately, which flows from these, it's commanding respect of your peers, commanding respect of other international lawyers, and then I ask them, well, ask yourself based on the profiles, which candidate sort of has these, and I think the answer is self-evident. Whether they will think that remains to be seen in November.
It sounds like a solid elevator pitch, Prof. We'll leave it there for this afternoon.